What is the difference between a will and a trust? Well, let's talk about wills first. A will does many important things. First of all, if you have minor children, that's where we appoint guardians for them. So that's the first thing that we want to do. Second, it decides who will be in charge of your estate on your death. In Arizona, we call that a personal representative. So we appoint that personal representative by way of a will. Then, of course, the will also says, where does your property go upon your death? That's an important part of putting a will together as well. What a will doesn't do is almost as important as what it does do. A will doesn't transfer your property on your death. That surprises a lot of people who come into my office. But think about it. If you have a home, how did you get that home transferred to you? It was by way of a deed. We have to have a deed of some type to transfer that property. Your heirs can't take the will down to the Maricopa County recorder and say, please transfer that house to us. We actually have to then file a probate, get that personal representative formally appointed by the court, and then they can transfer the property by way of the deed or whatever other form of property you have, transfer it to them. So as you can see, if you have a will, you're probably going to end up in probate if that's all you have. With a trust, what we do is we're setting up a document, but I like to think of the trust more as your treasure chest. What we're doing is we're taking your property and we're actually retitling it to the trust. So we're setting that up so that you now are the trustee of your revocable living trust, and you're the grantor and you're the beneficiary. You then manage your property within the trust during your lifetime and while you're alive and able. But if you're incapacitated, the trust permits your next trustee, the person you've appointed to step in if you can't, to take over. They begin paying the bills. They make sure that you're cared for financially. They take care of everything that's within that trust. With the will, it doesn't take effect until you're deceased. So as you can see, the will doesn't help if you're incapacitated. The trust, in fact, does. Then on your death, with the trust, we again have a trustee already appointed who will step in and can manage your estate. They make sure your debts get paid. They make sure that your funeral expenses are taken care of and all those kinds of things. And they start to wrap up your estate. They don't have to go to court to do that. They've been appointed trustee by your trust, and with the proper documentation put together in our office, they then can hire the realtor to sell your home. They can transfer your car if you've given it to someone, and they can liquidate the estate and make that final distribution to the people that are supposed to get your estate. A lot of people mistake living will with a will. So when we're talking about a will that distributes your property, it's your last will and testament. A living will is actually that end-of-life document. It's the document where you say, if I am terminal and my death is imminent, or if I'm in a persistent vegetative state, here's the type of care I want. For instance, I only want comfort care. I only want pain relief, and just let me go at that stage. So a lot of people come in saying they want a living will, when in fact what they're really looking for is that last will and testament. So we've talked a little bit about the differences between wills and trusts. And so I really favor the revocable living trust for most people. It really does provide a much easier way of dealing with your estate. For the people who will be stepping in to take care of your finances if you're incapacitated, or to wrap things up on your death, it's a much simpler process for them. They can immediately take charge of your estate. They can immediately begin making sure the bills are paid, that your health care is paid for if you're incapacitated. And they can immediately make sure that they're marshaling your assets and taking care of those assets to distribute to your heirs on your death. With the will, we end up having to file a probate on your death. And as we discussed, the will doesn't do anything for you during incapacity. It only takes effect on your death. With the probate in Phoenix, Arizona, we do have some informal probate, which is a lot more streamlined, but it's still a cumbersome process. There's still a lot more involved in that for someone who's trying to wrap up your estate than there is for a trust. And in my office right now, I charge more for the informal probate than I charge for the revocable living trust plan. An important part of making sure your estate plan works for you if you have a revocable living trust is making sure that you have retitled your assets to the trust. In our office, we help retitle all of your Arizona property to that trust. That's part of what we do. We also provide you with the documents you need to take to the bank to change the title on your bank account and to take that to your broker. And we work with you on beneficiary designations for your life insurance and for your 401k to make sure those are all coordinated to make your plan work the way you intend. So feel free to call us if you'd like to get more information about an estate plan or put something in place for you. We offer that first consultation free of charge. Just call our office or give us an email and we'll get something set up for you.